Begin time now. We are proud to affirm resolved in Google LLC versus Oracle America Inc. SCOTUS should rule in favor of Google. I'm going to talk about three things in this speech. Firstly, some context for what this case is about. Secondly, our plan and framework. And then finally, two advantages or arguments for our side. So first of all, just context, what is this case about? The basic gist of it is that what happened several years ago is basically that Google used what are called APIs in its Android operating system or Android OS. And basically what happened was that Oracle had claimed a copyright on that sort of Java code. And basically what happened was that in response, Oracle sued Google, claimed that its usage of its code violated copyright and was not fair use insofar as Google was using those APIs without the explicit consent of Oracle. What wound up happening subsequently is that the federal district court initially held that APIs are not subject to copyright. And insofar, like the initial ruling said that basically that Google was in the right because Oracle couldn't even place the copyright claim. Subsequently, when the case was appealed to the Court of Appeals to the Federal Circuit, that reversed that turning and said that, yes, you can copyright Java APIs. But what they left open was the possibility that even if you can copyright this API, Google can still use it in its code for Android OS insofar as it's fair use. That's going to come up in our case later on. The basic gist of this debate is just like, is it legitimate for Google to use those APIs? It's approximately 12,000 lines of Java code. And insofar as it is A, legitimate for a company to claim copyright over code, and B, even if it is legitimate, is this specific instance a case where it's acceptable? So what is our plan? The agent here, what? Sorry. Oh, yeah, it's application programming interface, I believe. I should have said that. You're right. Yeah, Tucker, is that right? I think
that's right.
Awesome. Cool. All right. Awesome. I should have said that. You're right. I should have written that down somewhere. Awesome. Yeah. I'll begin. Yeah. All right. So what's our plan? We're saying that the agent here in terms of enacting the plan is just the US Supreme Court or SCOTUS. The mandate here is just that the Supreme Court in Google LLC versus Oracle America Incorporated would rule in favor of Google by saying that their usage of API is protected under fair use. The time frame is whenever the court decides to take and vote on this case in the upcoming term. In terms of what the framework for this debate should be, is we're going to say like sort of the framework here is one of constitutionality, i.e. what ruling would be most in line with the Constitution and existing legal frameworks. It's not per se a debate about what side is the greatest good for the greatest number of people, but what ruling is the correct ruling. If we can prove that this is the correct ruling, we should take this debate. So given that context, first advantage I want to talk about is why Google's usage of APIs does fall under fair use. I secondly want to talk about sort of the broader scope in terms of societal benefits and why that fits under our framework. So first advantage, Google's usage of APIs was fair use. Notice that the sort of standard we're talking about here is the notion of fair use. The basic idea behind fair use is that it's a legal doctrine in the United States that is recognized by the Supreme Court that permits limited usage of copyrighted material, even if you haven't explicitly required permission from the copyright holder to use that copyrighted material. This is recognized in things like, for instance, music, where you can like put particular forms of music in particular online platforms if it serves a sort of common good and is in some way transformative. We say that there are two structural reasons then as to why Google's usage of APIs was in fact fair use. Notice that if we can prove that Google's usage of these APIs, of these application sort of Java code, was in fact fair use, we automatically sort of win the clash on constitutionality, because what we've been able to prove then is that this usage does not violate does not violate copyright law. So first reason as to why this is the case is just that broadly speaking, we think that this is a transformative usage of this code. What we're going to say is that in many ways, code, i.e. programming, is very different from other types of copyright. So for example, if I write a book and I copyright that book, if someone else were to take like 3 chapters of that book and publish it themselves and then make a lot of money off of that, that would be illegitimate and a violation of copyright because I have made that intellectual property, someone else has taken it and has not in any way meaningfully transformed that. What's different about this here, though, is crucially, is the context. So what are we going to say here? We're going to say that if company A, in this instance Google, writes 12,000 lines of code that are similar in nature to 12,000 lines of code that were written by company B, but company A is using it for a very different thing and in a very different context than company B, i.e. Oracle, what it is effectively doing is transforming that code. Because even if company B was the first one to quote unquote write that code or to write the method headlines, it's ultimately company A, in this instance Google, that's using that code to do a fundamentally different thing. So what is the fundamentally quote unquote different thing that Google did to transform the usage of this code? What Google did specifically was it used these application programming interfaces, or APIs, that were copyrighted by Oracle and the sort of Java programming language, more broadly speaking, to integrate a whole range of functions into the Android operating system. Like, not to get overly technical, but the whole reason as to why the Android OS system functions, and the reason it functions differently than, for instance, the iOS system, is because of the fact that it uses these APIs to integrate different applications in different networks together. So why does this matter? The reason why this matters is because, broadly speaking, the fact that Google used this code in a revolutionarily new way that was totally distinct from what Oracle intended that code to be used for means, functionally speaking, that it is fair use, because it is a transformation of that software. So even if Op can, for instance, prove that the nature of this code is similar, it's irrelevant, because insofar as it's used in a transformative way, it falls under fair use. But the second reason we're going to forward as to why this does fall under the sort of legal doctrine of fair use is because of the massive sort of broader benefits this has to society writ large. Notice, crucially, I sort of already mentioned this earlier, that application programming interfaces have enormous power, because what they basically are just a collection of previously established like software programs that can interact with one another. So basically what an API can do is sort of condense a lot of commonly used code into a much smaller amount of code, and just makes it a lot easier for programmers to do the things that programmers do, like add new functions to particular pieces of software. The reason that this is important is because when Google is permitted and has historically been able to use these APIs, what it does is make a better program that ultimately benefits the sort of public good, and therefore we say falls under common fair usage. Second argument that I want to talk a bit about is just why we're going to buy into a somewhat like activist conception of the court that says that if this does a massive good for society, it should rule in accordance with Google. So why do we think that, broadly speaking, it is crucial that the Supreme Court establish a precedent that sides with Google? What happens on their side when you rule for Oracle is that you effectively establish a precedent that allows technological corporations to monopolize the software and programming market. Because what you give companies the ability to do effectively is to monopolize and to copyright code. What is the problem with this? The way that coding works is that people write software for vastly different purposes. The fact of the matter is that might look similar code, but it does vastly different things. The problem is that when large technological corporations like Oracle get the ability to monopolize that market, it decreases innovation, because all of a sudden no one else can use that code, and that one company has a monopoly on the market. Why does this matter? We're going to say that what the Supreme Court should do, in addition to just ruling with existing precedent and existing constitutionality, is should sort of push for the best outcome for society here. And the reason as to why we get that better into our side is because we get better innovation, so far as more companies can use this code, more companies in the future aren't stymied by this precedent. We're very proud to affirm.
Cool. Okay. So unless anybody is not ready, my time. Wait, hold up. Let me get my timer out. My time will be beginning now. Okay, so first off, I want to address the definitions and framing that is provided by my opponents in this round before I move into our one main contention, and then I go into refuting my opponent's case. So first off, we will be agreeing to their definition of what happened in the context of the case, and we are ruling their plan as being valid and not like non-topical or whatever. Furthermore, we want to go into their framing of constitutionality. We do agree to this weighing mechanism, but I want to stress, and this will come up later on in my case, that we should not be at all weighing what will be net beneficial to society, overall most beneficial for society. This means things like preventing monopolies, as my opponents propose in their case. So we shouldn't be weighing those things whatsoever, and I'll be elaborating on that further on as I go down the flow. So that'll be moving into our one main contention, which is about how this has been upheld previously, and how it all be how the ability to copyright how the ability to have these broad copyright claims already been upheld and already is legal. The main example of this would be looking at the case of Eldred v. Ashcroft, which gives Congress broad latitude to enact copyrights, which basically means it was a bad tag. President upholds the federal court's decision. Cool. Okay. So what we can see here is that it's basically giving a the broad ability to enact copyrights on even specific things such as the usage of an API that on this specific case is about. What we can see here is that this is going to be a fundamentally constitutional thing because of this actual other Supreme Court case that the Supreme Court decided on. They can't go back on their own decision. That would be not constitutional, and that would be following the precedent that my opponents are also seemingly trying to follow under. So without moving into my opponent's case, the first and I think only contention was about how it falls under fair use. So first off, they talk about how fair use, how it's a legal doctrine and allows for limited use. Usage. What we have to understand here is, even as my opponent supposed, it's only under specific circumstances. It isn't a broad approval to use just a small amount of whatever you want to use fairly. What? Isn't a broad approval to just use whatever you want without any kind of restrictions. It was even ruled by the federal court this wasn't an example of fair use, specifically because it was being used not in a transformative, not in a creative process, as my opponents are talking about, but rather it's just being used because for the sake of saving Google time, rather than having them actually try to create their own code. And it's fundamentally not a transformative or creative process, which I'll elaborate on further now that I'm moving on to the second point of how it is fundamentally a transformative usage. What we have to understand here is that this isn't a transformative usage for a few main reasons. Firstly, the code is being used for the exact same thing that Oracle's code was intended to be used for. That's fundamentally what an API is meant to do. It's a machine readable interface between two programs. It's fundamentally doing the exact same thing it was meant to do in the first place. So it's not transformative. They're just using the exact same code for the exact same thing. Furthermore, we can see that it's clearly not transformative by looking at other examples of what transformative use is considered. Transformative use is often transformative use is often cited in examples such as people using parts of something else for a parody or for commentary. They're actually transforming something. This isn't transforming anything. It's not actually making it different in any sort of manner. Now, the second subpoint here, I believe, was about the better benefits. Furthermore, just elaborating. Once again, it's also not a creative use as my opponent seems to be proposing. Again, because it isn't actually transforming anything and it's not actually creating anything unique out of it. And as the federal court said, it was basically used only to save Google time, not actually to create any larger benefits or actually any kind of transformative or creative function. Moving forward, my opponent's, I believe, second subpoint was talking about how it is how the broader benefits to society are important. Well, first off, just as I said, we shouldn't consider any of this. This is not relevant at all in this round, given the framing mechanism that my opponents provide of constitutionality. And furthermore, we can see that even the arguments about how the Supreme, and furthermore, we can see the arguments specifically about these harms to society. The Supreme Court has already previously ruled in favor of these things being constitutional. The Supreme Court has a multitude of times ruled in favor of extending copyright rights and expanding the ability for companies to form monopolies. So there's no reason to believe they wouldn't rule in favor of that now on the argument that it's unconstitutional, seeing as they've multitude of times ruled constitutional in a multitude of other cases. So for these reasons, we can clearly see that the Supreme Court should be voting for Oracle in the case of Google v. Oracle.
Okay. Is everybody ready? Yeah. I'm sorry if this speech is bad. I'll do my best. I'll start now. A couple things on framing, then I'm going to go into responses to their case, extend some of our analysis. Okay, Judge. So first of all, I've been extensive like my partner Ryan's framing. When we talk about the framing constitutional, it's basically the framing is basically upholding the way Supreme Court justices rule on cases, right? And there are two sort of ways you can do this, right? You can talk about judicial activism, or you can talk about just like interpreting law directly. My partner comes up here and tells you we should be operating under judicial activism, and in that frame, you don't just consider, right, constitutional, just like the direct word of law. You consider like what benefits it has to society. We'd say judicial activism is like key for a couple of reasons. Basically, it's good because it allows Supreme Court to check when people pass bad laws. Keep in mind, the point of the Supreme Court is to make a slower moving body, so basically it can check when the fast pace faster, at least paced bodies of the executive and the legislative make bad decisions. And the thing is, sometimes those bodies, right, those the legislative and this executive body, try to do bad things under the guise of the Constitution. And therefore, the only way to check back against that when it is constitutional is through judicial activism. That's why we think judicial activism is an important frame to evaluate this round under. What do we say here in terms of like weighing this round as a whole? And sort of going to be a model through our whole case. We say first, A, if we prove a benefit, we win under judicial activism. And they haven't yet disproved why judicial activism is bad, right? But even if we don't prove like a net benefit and it's like a net neutral, then B, we win under the decision being the correct one. That's sort of like our modeling out for how you should vote on this resolution and vote for our side. So we're going to go into the fact that like, you can just extend all the benefits, terminalize them to like monopolization of the technology industry. Like we already see it being monopolized. You see how harmful it is to like competitors and they just get bought up by Facebook. Like impact that out even worse, right? You're giving them even more of a chokehold on technology as a whole. But so basically, like you can see those harms existing. They don't refute them, extend those across the flow. They don't actually give you a reason for why like you shouldn't consider judicial activism other than just saying no. So like you can just extend all our arguments. I think MO needs to respond to it. But let's talk about what this case is really about. So side opposition comes up here and tells you like a lot of stuff about why you can copyright what's it called, APIs. We'd say this case, right, is going to Supreme Court is not necessarily about the part about copywriting APIs. The question of the case going to Supreme Court is whether the use by Google was fair under fair use. The case is about when APIs are copyrighted, how do you consider fair use of code? We think that is the debate we should be having. And it's not this debate about whether this code, these APIs can be copyrighted. It should be about when APIs are copyrighted, how can they be used under fair use? Why is this important? Ron gives you a bunch of characterization about APIs and how they're very different than other types of copyrights, right? Because when you have writing, what ends up happening is that same text can only be used really in one way. And so when you copyright it, when you copy it word for word, there's like really nothing else transformative you can be doing to it. What is the differentiator here? We tell you the nature of code is basically creating a machine. And so what is really copying an API? It's like copying like a gear or a cog in a machine. We think if you use a gear or a cog and creating this bigger machine, that there's something very different than how it was used in the first place in a separate machine. That person who like made that cog is not owning your whole thing that you created. You are transforming that cog into doing something more and something better. And in that case, it is transformative. We think, if anything, for the Supreme Court, when we're considering code and copyright, you need to consider that transformative in the context of like copyright of code. And that's why it would be fair use. Let's go into their arguments now after like all of that sort of rant I gave. Their first contention is basically, they cite some Supreme Court case. They say, look, there's precedent. Well, like precedent doesn't mean it's right. Like there was precedent for segregating schools doesn't mean it was constitutional to segregate schools. We reversed that decision. I don't think precedent matters like that much, if at all, when you don't actually explain the arguments used in the case or give any reasoning to why this case lines up with those arguments or tell us why those arguments were good in the first place, right? It's like disallow most of their offense on their first contention to the point where like they don't actually explain the argumentation for why that precedent matters. But like further, we think a lot of their argumentation on this first contention, or I think it was their only contention, I had trouble flowing this, but was basically like, look, you can copyright code. Okay, fine, you can copyright APIs. Prove to me that it isn't transformative. Then we can give an opposition ballot. But you haven't really done that. So let's go into the bulk of this argumentation, where basically you tell us it isn't transformative because it's used for the same exact thing. We think it wasn't used for the same exact thing to the point where you were using it to create a different product. When you're telling me that this code was used the same exact way that Java made it to be, what you're basically saying is at the very low level, yes, that strip of code may have done the same thing in isolation as the way it was designed by Java. However, the bigger picture look at it is that no, this code didn't do the same thing. Why? It's because in the bigger picture, it was part of a new machine that created a different output than anything Java had ever created. That's why it's transformative. And if you want to talk about parodies in music, right, one could argue, look, the notes being used in the song are the same exact thing. Therefore, it isn't transformative. However, what's the differentiation? When you parodize a song, the thing you are creating has a different purpose, a purpose to create humor. And so while, yes, the beat and the notes may be the same exact notes copy-pasted, the thing as a whole you're creating using those beats and notes has a different purpose, has a different goal, which is why parodies are considered safe under fair use. For the same exact reason, because the code is being used in a different way to create a different, bigger picture outcome, we think that fair use in the context of APIs should be allowed when you're using that API to create something else, a different machine that does something else. And so for that reason, it is transformative, right? Because it creates a different outcome. And therefore, like a lot of their argumentation about how it isn't transformative falls under that analysis. So basically what we say here is that this argument, this whole debate really comes down to like, A, is there a benefit and do you buy the judicial activism framework? If so, you vote for us. We need to see argumentation out of MO. And if not, if you don't buy judicial activism, they still need to provide like some layer of argumentation that proves it isn't transformative. And we don't see that argument happening on the flow so far. And for that reason, because I think it's quite clear that in the context of code, it's crucial to note that like it's different than writing to the point where like when you copy paste the same lines, it isn't really doing the same thing in the same way. Like copying like the same 3 chapters of Macbeth still gives you the same message that you're getting from Macbeth, and therefore you're not really transforming it. That in that note, like basically you are getting transformative work. I'm so proud to propose.
Hi, can everyone hear me? Can everybody hear me?
Yeah.
Yes.
Okay. Good afternoon. Good evening. My name is Tucker Archumi. My pronouns are he, him, and let me give a brief off-time roadmap at mortal speed. First, I will be going over the framework, discussing what constitutionality means. Then I will be going into what the negation has read, discussing exactly what the precedent that we cite is. And then I'll be going over the affirmations case, talking about what fair use really means. Now, is everybody ready to begin? My time starts now. First, onto the framework. Prime Minister gets up and says that the framework should be constitutionality and that we should not be weighing on net benefits. We agree with that, but, and then member of government gets up and says that actually the framework was upholding the way some judges rule on cases with both, or using both judicial activism and judgment on the merits. Well, the name, or I guess the name of the framework, constitutionality, is prima facie proves that we should be excluding judicial activism, as prior Supreme Court precedent, Marbury v. Madison, indicates that the Supreme Court has the power to review law, has the power of judicial review on laws. That is, they can strike stuff down, but they must use it wisely. Marbury v. Madison says that the Supreme Court can strike down laws and rule on constitutional questions, but they cannot rule on political questions. And judicial activism then becomes the disallowed use of the power vested in a sitting Supreme Court justice to rule on political questions. Judge, you should reject judicial activism and vote for the framework as both the Prime Minister and the Leader of Opposition stipulated. Now, they say the purpose of the Supreme Court is to check back against bad laws. Yes, but only insofar as those bad laws are unconstitutional. the Constitution itself and Supreme Court precedent in the form of Marbury v. Madison, perhaps the most important case in Supreme Court history, proves that. Now, and furthermore, judicial activism can be misused in cases such as Planned Parenthood v. Casey, where the right to an abortion enshrined in Roe v. Wade was fundamentally restricted, and in the infamous Bush v. Gore, where Republican justices decided 5-4 to essentially hand the election to George W. Bush, using a very disingenuous argument. Now, let's move into the negations case. The affirmation argues that the question in this case is about when APIs can be copyrighted, and reads this analogy about cogs in machines. Essentially, if you have a cog in a machine and you take it out and copy it and then use it in another machine, that is a transformative use and so should not be subject to copyright. Here's the rub. Designs of machines have never been subject to copyright. They're subject to patent rights, which is fundamentally different than a copyright. A patent is granted when an application is submitted to the US Patent Office and approved. It describes the nature of an invention and an apparatus that implements it, and it grants exclusive power, or it grants manufacturing exclusivity to that product for a period of 20 years. A copyright is different. Copyright covers creative works, and Congress has decided that the definition of a creative work should extend to a computer program. The Supreme Court has generally agreed with Congress in matters of copyright, holding that the constitutional power to promote the progress of science and the useful arts by establishing for limited times rights of copyright and patent, that is directly quoting from the Constitution, gives Congress power to enact laws protecting copyright and patent rights. This is the Supreme Court ruling in Eldred v. Ashcroft that we cited earlier. So there is absolutely no copyright whatsoever in machine parts, whereas it is stipulated that APIs can be copyrighted by both the affirmation and the negation. So the precedent of the Supreme Court upholds the Court of Appeals of the Federal Circuit's decision, in summary. Now let's move to the affirmation case. The fundamental issue the fundamental point of clash in the affirmations case is whether or not the use is transformative and thus fair. Now, let's define what fair use is. Fair use is an exception to copyright protection, and a use is fair when it satisfies 4 factors outlined in copyright law. 1, the amount of work used must be fair. 2, the nature of the use of work must be fair. For example, parody or critical commentary or educational use is more fair than blatant copying. The effect on the market for the work must not be catastrophic, and the context of the use must be considered. Commercial use is weighed less favorably than nonprofit use. In the setting of this 4-factor test, Google fails each point of them. They copy this API wholesale. They use that copy to write a library that does the exact same thing that that Oracle's library does, but at a price that is cheaper for them. So and in a commercial manner. So we can see that the four-factor test here weighs heavily in favor of Oracle. Now, the member of government argues that the use is transformative because the library was not used for the exact same thing. It was used to create a new product. I don't think the member of government understands exactly what the issue is here. So the Android operating system is an operating system for mobile devices that runs using the computer programming language Java. Google decided to use the computer programming language Java to implement Android. That is their decision. They could have used another programming language. And to save on licensing fees for Java, they decided to write a library to replace Oracle's library. So insofar as so what is being disputed is the library that Google wrote to replace Oracle's library. Google's library is not transformative. It's doing the exact same thing that Oracle is doing. And so for this reason, Judge, we strongly negate the resolution that in the case Google v. Oracle, the Supreme Court of the United States should rule in favor of Oracle. Thank you, Judge.
Okay, yeah, I won't go that fast. I've only got 4 minutes anyways. My time will be starting now. Okay, so first we're going to be looking at some framing, namely my opponent's weighing mechanism and their proposal of looking at judicial activism. What we have to understand here is that we shouldn't be weighing anything based on judicial activism for a few reasons. We shouldn't be weighing this round based on judicial activism for a few reasons. Now, my opponents talk a lot about how judicial activism is a positive force and how it is being able to be beneficial, and is how the Supreme Court frequently rules on things. Now, there's a couple of things here as to why we should not be preferring judicial activism to just straight constitutionality. Firstly, it is not constitutional, as my partner cited. As my partner cited in the case Marbury v. Madison, it has been already decided that it is not constitutional for Supreme Court justices to rule on political matters and to rule for the sake of politics or personal ideals. Namely, basically, that judicial activism is inherently unconstitutional. Furthermore, what we can see is that we also should not be considering judicial activism because it is not ultimately going to be a beneficial thing to society. My opponents put a lot of their case on how important this will be and how good judicial activism is, but what we have to understand here is that it isn't good. Judicial activism is also what allows for taking away abortion rights, and is also what allows for cases like Bush v. Gore to go through the Supreme Court and the results in the outcomes that do occur. So what we can see here is that just as likely, if not more likely, for judicial activism to work in a negative fashion as is for a positive fashion. So we shouldn't be preferring it on the grounds that it is somehow benefiting society. So without moving into our first of two main voting issues, which is about how it is which is about the president of this case. What we can see here is there is set precedent by the Supreme Court that this that copywriting an API is legal, and that holding a copyright on an API and preventing another company from using it illegally is also legal. My opponents say that precedent doesn't matter, but quite frankly, what to look at here is that the Supreme Court decides primarily based on precedent. So what are my opponents proposing that we weigh on, especially seeing as they themselves propose things that have been decided based on precedent, such as transformative uses. There is precedent supporting the transformative usage is illegal. So if we don't buy this, we shouldn't be buying any of my opponent's case either. Moving forward, our second voting issue, which is about how it is not transformative usage. My opponent's entire case rests on the idea that it is transformative usage, and this is entirely false for a few main reasons. Firstly, we can see that they fully copied the API. They didn't actually create anything unique. They didn't actually create anything for themselves. Secondly, we can see that it was again used to create something that did fundamentally the exact same thing that the API did prior to them copying it. Meaning they didn't create something new and ingenuitive, as my partner stated, they fundamentally which created the exact same thing, but for them instead of someone else. Which brings us to our third point, which is that how it is being used for commercial purposes, meaning that it isn't used for the sake of education or for the sake of critical commentary. It is instead being used for the sake of Google turning a higher profit, and for that reason, it cannot be a transformative usage, and it cannot fall under fair usage, as my opponents propose it does. So for these reasons, we can see that the Supreme Court should rule in favor of Oracle in Google v. Oracle.
All right, awesome. I'll begin now. Once again, we proudly affirm. I want to look at two major points of clash in this debate. First, on the question of constitutionality and how the court should rule. Secondly, on societal benefits and the clash on framework. But to be very clear, I just want to be very clear about this. If we can win the clash on constitutionality, that the court ought to rule in favor of Google, even if we lose the whole clash over judicial activism, it's irrelevant because the opposition team doesn't gain any offense on that clash. So if we win the clash that Google has won this case or should win this case, we take this debate. First point of clash then, how should the court actually rule in this debate? I want to point out that opposition spends a considerable amount of time, even in the previous speech, talking about why copywriting APIs is legitimate. This is fine, but it's not really the major clash in this debate. Neither team is talking all that much about whether or not it's fair for Oracle to place a copyright on APIs that it's developed or the Java programming language more broadly, but rather whether, given that the existence of that copyright, whether or not Google's usage of it is legitimate. So the fact that OP proves that we can copyright APIs without any legal qualm is not particularly important in this debate. So in the same way that, for instance, you might be able to copyright something like lyrics or particular forms of creative expression, but if I use those same exact forms of creative expression in a fair way, it's still legal and protected under copyright law. So the first thing I want to deal with under this point of clash is just to briefly deal with the arguments we hear from the member of opposition that are sort of new responses to what we gave from both PMC and MG. Well, we're told that there's this sort of four-tiered standard for whether or not something is considered to be fair use. But I want to be really clear as to why pre-existing analysis proves that all four of these flow to our side. First of all, they say that the amount of work that's used has to be fair. Like, as a person that's actually programmed in Java before, right? Notice that Java has literally billions of lines of code. And as we mentioned in case context, this debate is about 12,000 lines of code, right? So if MO is saying that this is unfair because we're stealing the whole Java library, it's not really the debate because we're talking about something like 12,000 lines of code in one API. But secondly, as Arnav also points out to you, Google did in fact change this code because they did in fact use it for a different purpose. So it's not like they just copy paste it right into their own software environment. They changed it around. Secondly, they say that the nature of this work has to be fair. But that's exactly what Arnav proves to you, right? So in the same way that, for instance, if I make a musical note, right? If I sing and I sing a concert C and someone else also wants to sing a concert C, it's not legitimate for me to say oh, I put a copyright on the note concert C, therefore I can sue the Sound of Music because they violated my copyright. The reason for that is for the exact standard they give. This has to be fair in nature, which is exactly what Google did when it took software that Oracle developed for an entirely distinct purpose and used it for developing the Android OS system entirely distinct. Thirdly, they talk about the effect on the market of this work, but this is unclear why this flows to their side, right? If anything, the construction of the Android OS system was enormously advantageous on net and did not substantially harm Oracle. If anything, this probably benefited Oracle because more people are all of a sudden using that API. But finally, they say the context for this use has to be considered. And that is exactly our argument. The context where Oracle is using this to do random data entry fillings in the back of its networks is considerably and infinitely different than when Google is using this to construct an entirely new operating system. So at the end of that, what I want to be clear about is that by the four standards they lay out in this debate, we take the clash on, is this fair use? But I want to be really clear about why all the pre-existing analysis we give wins this debate independently. They respond to the example that Arnav gives about cogs and machines, but don't really respond to the underlying analysis. And here's the underlying analysis. When company A generates or writes a particular amount of code, and a different company uses similar code to achieve a totally different outcome, the reason that's considered fair use is because what you are doing with that code, even though it's similar, is an entirely different outcome. So let me give you an example. If I write a Java program, a simple program that counts from 1 to 1,000, let's say I'm using that program to count how many debate rounds I've lost, and then Arnav uses the same exact lines of code, the same exact for loop that I've written, but uses it to count something entirely different, uses it in an entirely different context. The fact that I've copyrighted that Java program in no way means that Arnav's usage of it is not fair use, because we're using it for entirely different outcomes. Both teams agree fair use is fair insofar as it is substantially different, i.e. transformative, and that's exactly what we proved in this debate. So even if you buy all of the op stuff about precedent, it flows to our side ultimately, as we established. Now, the final thing I want to briefly mention, they talk a lot about precedent, this one particular case. Like, we never were given the details of this case. We don't even know what this case says or the way that this case ruled. So it's not altogether clear to me like what this case proves for them, this like edged or whatever SCOTUS case they reference, and the like considerable lack of warranting I think is problematic there. At the end of that, we win the clash on constitutionality if you weigh it up. On societal benefits, both teams agree we're talking about how the court should rule, but Arnav explains to you that the role of the court is not just to interpret the Constitution, like that's a part of it, but also to interpret it in a way which checks back against abusive laws. We point out, therefore, that this is an abusive instance of that because it allows for the monopolization of the industry overall. So if you think that we've won the clash on constitutionality, we win. If you think that the framework clash flows to our side, we also win because we proved to you the monopolization on code and the detrimental effects affirm.